but there have been two cited issues for a few years now, some infidelity and some things like that. I think now they're finally at a point where they're really able to.
Well, if people cheat on you, you have two options. Either you accept it and you forgive, or either you tell them, I'm not going to be with you anymore. Court is calling 2023 CR 10531W, State of Texas versus Pio Quinto Leon. Can I have parties announced for the record for the state?
Second for the state, Your Honor.
Kim Gonzalez for defense.
And are you Mr. Leon?
Yes, Your Honor.
All right. And you're standing in because?
For Mr. Locke, that she had something this afternoon he had to be on time for. So
Okay. It has Jennifer Locke listed as the attorney.
that may be because she's on the bond judge.
Okay. All right. Counsel, have you received all the discovery that you reviewed with your client?
Yes, Judge.
All right. And do you have any objection to this attorney standing in?
No, Your Honor.
I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did
Yes,
you
Your Honor.
understand it?
Yes, I understand.
And did you sign it?
Yes.
Going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and the Code of Criminal Procedure, Article 26.03. Did you have a chance to review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear this case and make a decision on whether or not to hold you over for trial, i.e. indict you? Did you understand?
Yes, I understand.
Did you understand that your attorney has certain rights, namely 3 days from the presentation of the information, 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, I understand, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, I did understand, Your Honor.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Liam, I'm showing you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, all of the above, Your Honor.
All right, off the record. Deputy Mejia, could you move them down to that end? We're back on the record. Did you understand you're charged with the offense of violation of bond, protective order, assault as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, I understand, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I understand, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, I understand.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, I understand, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against?
This opening already hints at the root of the case: relationship chaos spilling into the courtroom. Judges hear infidelity a lot, but what matters legally is how people respond to it. Emotions don't excuse criminal conduct. Do you agree?
Yes, I do, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Leon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I understand that.
According to the plea, state is recommending deferred adjudication. This is run concurrent with 2022 CR 9798, taking consideration grand jury number 802090. They're going to reject grand jury number 809802. There's an affirmative finding of family violence. There's to be no contact with Adriana Leon. Did you understand that to be the plea?
Yes, I understand.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did
Yes,
you
I
sign
reviewed
it
it.
in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I was.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years, and you are to follow all civil orders regarding child custody, I'm assuming. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I understand, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, have you any evidence?
Yes, Your Honor. State offers states 1 and attachments.
No objections, Your Honor.
All right, and have you spoken to the complainant?
We have, Your Honor.
And is the complainant aware of this agreement and in agreement?
They are, Your Honor. Yes.
All right. You may continue to confer.
Thank you, Judge.
Going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I do understand.
Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, I understand, Your Honor.
All right, off the record for a moment. Can I see the state
Yes, Your Honor.
and defense? And defense, you have no objection with the court proceeding on the affidavit?
That's correct, Judge.
All right, court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are prepared to do that, Judge.
All right, anything you wish to say on behalf of your client?
No, Your Honor, we're just respectfully asking that the court follow the plea agreement. We've had lengthy discussions about what is and is not acceptable and what is expected of the court. And he understands that there is to be no contact going forward and that the only thing he needs to focus on is the civil issues going forward and keeping the kids in a safe place and worrying about following custody orders as well as your orders, Your Honor.
All right, so why shouldn't I send him to prison? That's my question.
Judge, I think there's been a toxic environment and relationship between the parties. I think they finally realized that, I know it appears to be one-sided, but there have been two-sided issues for a few years now, some infidelity and some things like that. I think now they're finally at a point where they're really able to.
Well, if people cheat on you, you have two options. Either you accept it and you forgive, or either you tell them, I'm not going to be with you anymore. I don't know why people think that infidelity means, oh, I get to hit on somebody. Oh, DeWalt, you raising your hand? Have you been cheated on?
Oh, no.
Okay. All right. I was like, what? All right. I was like, what? Because I don't believe that.
May I speak, Your Honor?
Yes.
I do agree, and I forgave her for doing that. She's been going in and out, cheating on me, and I respect that. I have not hit her at all. But yeah, I understand this has been a toxic relationship. I think it's best for me to have no contact with her.
All right. Are you employed?
Yes,
What do you do?
I work for SureMed. It's an emergency medical services.
All
I'm a
right.
driver.
Okay. Court is going to sentence you to 6 years deferred adjudication, the BIPP course. This will run concurrent with 2022 CR 9798. There's an affirmative.
Erase an important legal checkpoint. A third-degree felony with a possible 2 10-year range is no joke. Deferred adjudication sounds lenient, but it's basically a last chance. One mistake and prison is back on the table instantly.
Finding, and I'm sorry, did you realize with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, I understand.
And that you realize with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
And knowing that you still wish for the court to follow this plea bargaining agreement?
Yes, Your Honor.
All right, there'll be an affirmative finding of family violence. There's to be no contact with Adriana Leon outside of court proceedings.
Yes, Your Honor.
So when you're in court and you all are sitting at the table, that's as close as ever you're going to be to her. When she leaves the courtroom, you wait till she leaves the building and leaves the premises. Do you understand?
Yes, I understand.
Your relationship with her is over in the sense that you have no contact with her.
Yes.
If you all have a custody arrangements with the children, that needs to be done through a third party. You understand?
Yes, I understand.
That means that you are not going to send her a card saying Happy Mother's Day. You understand?
Yes, I understand.
The relationship is over.
Yes.
All right. There's going to be proof of employment within 30 days. No employment as a home health care provider or with minors. You are to follow all civil judgments and orders as it relates to child custody. There's to be 200 hours of community service restitution. You are to do intensive parenting classes. There's to be a rejection of grand jury number 809802. They're taking in consideration grand jury number 802090. There's to be regular UAs. I'm going to want field visits one time per month until further notice. How's child custody arrangements currently?
Right now, there's not any visitation judges.
All right. So I'm going to order no unsupervised contact with minors until further notice. If for some reason the civil side says he's allowed to have contact, unsupervised contact, then you all can come back to the court.
Yes, Judge.
All right. Probation, is there anything else he needs? We can do a TAP evaluation out of custody and follow TAP recommendations. If TAP recommends inpatient treatment, we'll start with outpatient treatment. All right. Is there anything else?
It's just we just want to make sure we had the withdrawal of the MTR. So there's no.
Oh, they'll have to file the motion. I haven't received it.
I think he has.
Your Honor, state's already signed up.
Okay.
And I believe that's it. But may we be excused?
Just a moment. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I understand.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. And I'm sorry, just one more thing, because I have concerns. I'm going to order GPS partial, and I'll waive the fees. And he's allowed to work, and he's allowed to go to all court hearings. And then if you want to approach the court in 4 months' time, you can come back. And if there are no violations, the court will strongly consider removing it.
Okay. We'll do that. Thank you, Judge.
Yes.
I apologize.
All right, we can go off the record. Here's the thing. I read the report, and honestly, the main reason that you are now on deferred adjudication and not at the prison is because the complainant wants you to be on probation and not at the prison. Do you understand?
Yes, I understand.
That day is a day that your 12-year-old will forever remember. And how many children do you have?
3 boys.
3 boys.
Yes.
So let me just tell you what your boys have learned from you and in this toxic relationship. They've learned that toxic relationships are the norm. They've learned that if you love somebody, you hit them. And it's going to take a lot to undo that. Do you understand?
Yes, I understand.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Hank Wilkins for the state, Your Honor.
All right. Let me call the case. The court is calling 2023 CR.
Waiving the right to appeal is huge. Once this paperwork is signed, the door to challenge the outcome almost completely closes. This is the moment many defendants don't fully grasp until it's too late.
3443, State of Texas versus Larry Everett Berry. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Kenton Longacre for Mr. Barry.
All right. And are you Mr. Berry?
Yes, ma'am.
All right. We're here for sentencing. Oh, this is taking a while. He entered a plea on July 10th. Okay. I see why it was taking a while. Your attorney was unable to appear. And then we had to have a mental health evaluation to be completed.
That has occurred. That's
All right. Have both parties had a chance to review the PSI report state?
I did at the previous setting, Judge, and I believe, is it 16 months opposed? Is that what?
Yes.
Okay. Yes, ma'am.
All right. Have you reviewed the PSI report?
we have.
Any objections to the PSI report state?
No
No, Your
objection, Your
Honor.
Honor.
Defense, any objection?
No.
All right, according to your plea bargain agreement, punishment is to be assessed at 16 months in the state jail facility. There's a $2,000 fine. The state opposes your application, and there's to be restitution for drug testing. State, you're opposed. Do you have any witnesses?
No witnesses, Your Honor.
Defense, do you have any witnesses?
No, Judge, none other than Mr. Barry. He'd like to say a few words to his.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Defense, you want to step back, please?
Sit and make a note.
That's okay. All right. Can you state your name for the record?
Larry Everett.
All right. Do you want to ask your client questions?
A few. Mr. Barry. Excuse me. Mr. Barry, on paper, you don't look like a good candidate for probation. Can you tell the judge why now, today, you are a good candidate for probation?
Everyone, please whisper, or either you cannot talk.
Yes, I would like to have probation to change my life. I got a job. I'm trying to be a better person. I'm staying out of trouble. I'm not out there doing nothing to society, anything. I'm just trying to be a better man to my kids and all that. And my son's birthday this Saturday, and I'm trying to get this opportunity to just do right.
Do you understand, we went over it from the court. You understand that the recommendation is some mental health treatment that could run about 120 to 180 days.
Yes, sir.
And you want that mental health treatment?
Yes, sir.
You want to get your mental health issues resolved finally?
Yes, sir.
How about the chemical dependency end of it, the alcohol and drugs? Do you want to get that issue resolved?
Yes,
before
sir.
we finalize?
Yes, sir.
So, and you do have a job now.
Yes, sir.
Who do you work for, sir?
I work for Sam's Burger Joint. I'm a cook there.
I understand. Anything further you want to add to the judge?
I hope I get the opportunity to get probation to get all the help I can through what I've been through and everything else.
Is it fair to say that what you've been through legally has been your responsibility? I mean, you caused it.
Yes, sir.
Agreed?
Yes, sir.
All right, thank you.
All right. Any questions?
Yes, ma'am. Mr. Barry, my name is Hank Wilkins. I'm a prosecutor here. I just have a few questions, and if you don't understand anything, okay, I don't understand that, but I'll try and phrase it a different way.
Okay.
But you've been on probation before, right?
No.
You weren't on probation for theft in 2010?
I'll remember. I probably have, but.
All right. You want to show him his criminal history?
Yes, sir. So this is on page 2 of the TAP evaluation here. Did you go over this with your attorney, maybe the lack thing?
Yes.
So on page 2 here, this is in January of 2010. You've got this theft, granted 6 months probation, and then it was revoked a couple of months later. Do you remember that?
No.
Okay. And then so that's a misdemeanor. But then do you recall in 2016, you were on probation for a felony assault family second offense? Do you remember this one?
Mm-hmm.
You don't? Okay. So you were granted 3 years deferred in 2017, and then you were revoked later in 2017. Do you remember that?
No, sir.
Okay. I believe there was another one out of state. Do you remember ever being on probation in Ohio?
I think so. I believe so, but I ain't been back in Ohio for years.
Okay. So it looks like you were granted 2 years of probation on a felony receiving stolen property.
This is where the courtroom tension spikes. The judge isn't asking out of curiosity, she's testing credibility. When personal stories start sounding like justifications, judges push back hard. You can feel the shift right here.
2000. Do you remember that?
Mm-hmm.
No, sir. Okay. Well, sir, it looks like you were revoked in 2002 for that. Do you remember that?
No.
No, sir. Okay. Looks like you had a domestic violence in 2003 that you got a year probation on. Do you remember that?
No. None of that.
Do you remember your probation was terminated later in 2004?
No.
No, sir. Okay.
I get back home. God know who.
So can you tell the judge why, if you're given the opportunity this time, it's going to be different?
Yeah, if I get the opportunity to get probation this time, everything will be totally different. I'm a working person. I don't sell drugs. I don't do anything anymore. I'm more of a family man.
Okay, here's the thing. Don't do that thing about I don't sell drugs. I don't belong to a gang. You know why?
Why?
Because I don't do drugs. I don't sell drugs. I don't belong to a gang. Half the people who are in here, well, I won't say half. I'd say a third. Like your attorney doesn't do drugs, sell drugs, or belong to a gang. So don't do that like you want a cookie for being a law-abiding citizen. You understand?
Yes, ma'am.
Now, the state asks you about your criminal history. Do you remember going to prison?
Here in San Antonio.
No, just prison, period.
Yeah, I've been there.
All right. So why are you pretending like you don't know about this stuff?
Because I don't know about the probation. I ain't never in Ohio. I don't know. I just always been locked up.
No, there's an assault case here where you were on deferred adjudication and it got revoked and you went to prison. Are you trying to tell the court that you don't remember that?
I can't remember because I was homeless at the time. I jumped from, I ain't had no place to stay.
No. But people will remember going before a judge and a judge saying, I'm no longer going to keep you on probation. I'm sending you to prison. You're telling me that you don't remember that.
No, because
that's odd.
I mean, I've been going through it like a hard time at the time. I don't really have no family here but my kids. I'm like the only kid down here from Cincinnati.
No. You're jumping over talking about different things that I'm not talking about right now. We'll get to your children. You have been to the state jail facility before. You've been to prison before, and you're making it seem like you don't remember any of this. Counsel, you want to step back and talk to him and see if he remembers his criminal history?
Judge, we have talked about it, but we've also talked about his mental health conditions, unresolved mental health conditions, which include bipolar and major depression.
I mean, you can be majorly.
As penalty history, he's been under the influence a lot of the time during a lot of his life.
All right, you can be bipolar, but you know if you've been to prison before. You can be depressed, but I think you know if you've been to prison before. If I'm wrong, somebody tell me and say, Judge, you're wrong. People who have been majorly depressed don't remember going to prison. People who are bipolar don't remember going to prison. People who are the only person in a particular state or city with no family members don't remember going to prison, because he's just told the prosecutor, and if I'm wrong, let me know. He's just told the prosecutor he doesn't remember any of these charges.
I understood him to tell the prosecutor that he didn't remember the probation revocations, which he and I talked about. And I made a point of saying, you've not done well on probation before on a number of occasions. Why is it going to be different? Why in the world would this judge do anything different? But he acknowledged that to me, that he recalled the state jail incarceration as well as the TDC.
All right. If you're drug tested today, what are the results going to be?
It'll be dirty. I ain't gonna lie.
Dirty for what?
Marijuana.
And what else?
And alcohol and I've been partying. Yeah.
Oh, what else? You say alcohol and I've been partying. So what else are you going to be dirty for?
Okay.
All right. And how often are you using cocaine?
Nah, not that much. It was like when I go to parties.
All right. Why are you going to parties and you're supposed to be so concerned about your children?
It was like football season and all that stuff. I go to places like that because I don't have cable at the time. I go to like friends' houses and all that.
And do drugs.
I don't choose to, but it just, if it's there, like when we win, because I'm a Cincinnati Bengals fan. Like when we win, it just slang way like.
Well, that's rare. Because Cincinnati Bengals rarely win.
Yeah, but it just, that's my team.
I understand. All right. Is there anything else from either side?
Nothing further, Your Honor.
Nothing further from us, Judge.
All right. You're going into custody today. This is what's going to end up happening. You can either go to the state jail facility or either you can go to inpatient treatment. Felony drug court, if they have a place available for you, then you will be at felony drug court. So do you prefer to go to the state jail facility, do your time of 18 months, or would you like treatment?
Treatment.
Okay.
Judge, if I may, the recommendation is not.
Judge, Mr. Barry has already been evaluated
for felony drug court, it does look like as of July 25th, 2023, he did meet criteria. However, he needed to be re-referred if he was granted supervision.
Yes. So that's what we will do, but he's going into custody today. And I know you may think it's wrong of me to put you in custody today, but guess what? Saturday.
An affirmative finding of family violence changes everything. No guns, no primary custody, no contact, even outside prison. Life restrictions stack up fast. Many people underestimate how heavy these collateral consequences really are.
Is upon us. Thanksgiving is upon us. And everybody knows Thanksgiving, I grew up Thanksgiving watching the Cowboys play and shelling pecans. But those are just breeding grounds for you to go to somebody's house and end up doing drugs. And guess what? The last time you do drugs may be the last time you do drugs. And your family members who are in Cincinnati or wherever they may be will have to come down and identify your body. Or either your children will have to identify your body. Do you understand? All right, I'm going to give you a chance. It's completely up to you what you do with it. And there was an application just for regular probation. So the court will sentence you to 16 months in the state jail facility, suspended and probated for 2 years. There's to be a referral to felony drug court, regular reporting by Zoom or in person, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a referral to felony drug court. If not accepted, then he'll go to SATF. If SATF is not available, then it will be ISF, substantive abuse track. Substance abuse track, sorry. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the 200 hours of community service restitution will be deemed to be satisfied. There's to be restitution to BCSO for drug testing. And let me see if we have an amount for that. State, do we have an amount for the drug testing?
It's usually $57, Judge.
But do we?
I think that's sort of what the standard is, 57 for either SAPD or BCSO.
All right, we'll do restitution to BCSO for drug testing if submitted. And that needs to be submitted no later than December 18th, whatever their restitution is. Counsel, if there's an issue with their restitution amount, just let the court know.
Yes, ma'am.
I'm going to want field visits 1 time per month upon release. And that will be for 4 months. And then it can be at probation's discretion. Who are your children with now?
With their mama.
Okay. And is there child protective services involved? Okay. Probation, is there anything else he needs?
No, Your Honor. He criteria for PRS. I'm not sure if his mental health issues go disqualify him from status if drug court does not.
All right, then.
Excuse me, Judge, I had a question in that regard too. I understood you to say status first, and if
No, felony drug court first.
I'm sorry, felony drug court first, if rejected their status, if rejected there, then the dual diagnosis.
No, then ISF. Since I know SATF will reject him then for the mental health, remove SATF from my order, and we'll try with ISF substance abuse track, and then if not, DDRF. And the reason why I'm doing that is because what is the wait time for DDRF?
8 or it just depends on if the individual is stable on medication.
All right. So we'll try referral to felony drug court first. And then if you can try ISF substantive track and DDRF. And they will let you know what the wait time is for DDRF and what the wait time is for ISF substantive abuse track. Okay. All right. Is there anything else you need from the court to be successful? Yes or no?
No, ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. If you have you reviewed that with your attorney? Did you understand it and did you sign it?
Yeah.
I'm sorry?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. So you have a drug problem. That's clear to the court. You have mental health problems. I do not know if your drug problem is caused by your mental health or not, but they'll be able to diagnose that for you once you're in the program. Do not be that person who gets a chance and then you continue to use. You understand?
Yes, ma'am. I got sick when I was in the prison. I got lung cancer.
Okay.
I spit up blood every day.
Okay.
I'm trying to get help for that, but they won't be. I ain't got no insurance. I just filed for Social Security.
Okay, so here's the thing. I understand and I appreciate what you're telling me about your issues. One, I don't have any medical documentation of that. And two, how do you think your lung cancer is going with you using cocaine? And are you using cocaine by snorting it, inhaling it?
I snorted,
That's probably not good for your lungs. Do you understand?
but I filed for Social Security. I just got my papers back, so hopefully I get granted or I could get insurance to get the help. But they won't pay $3,000 for the surgery.
Okay. All right. Well, good luck to you. Okay. Thank you.
This final warning is the heart of the ruling. Deferred adjudication wasn't granted because the court was convinced it was granted because the complainant asked for mercy. That's rare, and the judge makes sure he knows it. This is probation on the thinnest ice.